You are listening to the Justice in Heels podcast with me, your host, Danielle Hayward. Join me as I discuss interesting legal topics with inspiring female legal professionals who paved the way for the rest of us.
Hello and welcome to another episode of the Justice in Heels podcast. Today, I am joined by Megan Harrington-Johnson, who is going to speak to us today about forfeiture in divorce and then a recent development in cases where parties are married out of community of property without the accrual. Megan, welcome to the podcast.
Thanks for having me, Danielle.
So, before we start, can you maybe just tell our listeners a bit more about yourself?
Sure. So I am an admitted attorney. I run my own practice in Bryanston called HJW Attorneys in conjunction with my partner, Richard Wands. We set up practice 6 years ago after both of us having been partners at bigger law firms in Sandton.
Amazing. And why are you so passionate about family law specific?
Sure. So I've done all I can to try and get away from family law in the past, to be honest with you, because it is quite a taxing profession to be involved in. You're dealing with people's emotions a lot of the time, and people that don't necessarily want to be in a litigious environment. But I have spent so much time doing it. I think I'm in my 16th year of practicing family law that I have developed that passion and that interest, and I like being involved with individuals as opposed to faceless companies. So it is definitely a passion of mine as much as it is a taxing one to deal with.
Amazing. Okay, so on the topic of forfeiture, can you maybe just tell our listeners what is forfeiture in the context of divorce law and how does it differ from standard asset division?
Okay, so I think before we get into what forfeiture actually is, I think the listeners need to maybe have a better understanding of what types of marital regimes they actually are. In South Africa, we only really have 3 types of matrimonial property regimes. We have the automatic matrimonial property regime, which is in community of property, which is what happens if you don't conclude an antenuptial contract. Then if you conclude an antenuptial contract, we have married out of community of property without the accrual system, and you have married out of community of property with the accrual system. What forfeiture speaks to is the forfeiture of benefits that can arise from a marriage. So it would only apply to the marriage in community of property because ostensibly there are some benefits that can be gained when that marriage breaks down, and a marriage out of community of property with the accrual system, because again, there might be some benefits that are payable upon the breakdown or dissolution of the marriage. So what forfeiture says, and it's set out in section 9(1) of the Divorce Act, is that the court is allowed to order a partial or a total forfeiture of some of the benefits that arise from one of those types of marriages upon a divorce being declared, but it's subject to certain factors being taken into consideration. And those are the duration of the marriage, the length of the factors that led to the breakdown of the marriage, and then any substantial misconduct on the part of either spouse. That's essentially what forfeiture is in a nutshell. It's a difficult one to understand because South African divorce law works on a no-fault principle. So you can't say that you're not going to get anything out of a marriage just because you behave badly in the breakdown of the marriage. But there is this concept of forfeiture, and it's a very difficult line to tread, and it's not a completely clear line, which I think will segue quite nicely into the article that you sent that we want to discuss, because people try for forfeiture all the time and they don't necessarily come right.
So how often have you found your clients coming to you and saying, listen, I don't want my spouse to actually benefit from this marriage when we are getting a divorce? How often does that really happen?
Almost all the time. You know, when you see a lawyer, you are not a happy person. You are not wanting to be in this marriage anymore. And generally, you're quite pissed off with your respective spouse. So people get quite upset when we explain to them that, look, this is a no-fault divorce system. And just because your husband did something wrong to you doesn't mean that you don't have to pay him an accrual claim, or vice versa. You know, your wife cheated on you, but you now owe her half of your estate. It's a very bitter pill to swallow. So if you then try and introduce the forfeiture discussion, it becomes a little bit easier to swallow. But it's also, again, just because someone cheated on you doesn't mean that you're entitled to forfeiture, and it doesn't mean that you're entitled to a total forfeiture. So I would say 98% of the people that come to sit with me are dismayed to hear about the no-fault system.
So what are the grounds for forfeiture then? When can you apply for that?
Oh, it's so difficult because it's like asking me how long is a piece of string. You must remember that we also have judges sitting on the bench who have their own biases and own perceptions, and one judge might order forfeiture where another judge won't order forfeiture. I would say that the infidelity on its own is not necessarily a ground for forfeiture, and I generally would tell my clients that, even if you can prove the infidelity. But something like, for instance, a spouse having an entire different family in another province that they are supporting, that you knew nothing about, that might be a ground for forfeiture. So it needs to be substantial misconduct, which would really result in that spouse being unfairly benefited from the estate of the other spouse.
Okay, that makes sense. So then going forward to the case that I sent you. So for those who do not know, there was recently a case where a wife wanted her husband to actually not benefit from the assets that they accrued, because she thought that he was just not ambitious enough and that he did not bring his side in this marriage. Megan, so can you maybe just tell us a bit more about what happened there and what actually, like, what was the result ultimately?
Sure. So in this case, I believe the parties were married in community of property, and the wife felt that she had contributed much more to the marriage than the husband had. She said that he had lacked ambition, he'd rested on his laurels, he'd let her pay for the majority of things in their marriage, and all he'd really done is contribute towards the gardening of the household. That was one of the items that she'd mentioned in her list. But unfortunately for this wife in this particular scenario, it was held and decided that unfortunately this did not constitute grounds for forfeiture, even though the wife said he could have bettered himself, he could have studied more, he could have gotten a better well-paying position. The court found, unfortunately, that doesn't constitute a ground for forfeiture. And that goes back to the locus classicus in this area of law, which is Vaker versus Vaker. And Vaker versus Vaker says you can't avoid the consequences of a marriage simply because they're inconvenient to you or you don't like what they may be. And I think that that's what happened in that particular matter. In that particular matter, there were also allegations of infidelity, but the court wasn't called upon to decide the allegations of infidelity because there was no proof as to the alleged infidelity.
So do you foresee this, like, being not being ambitious, being a possible ground for forfeiture in the future, maybe if the situation was different, if the facts of the case were different?
I don't think so. I think it would be too convenient to try to get out of those patrimonial consequences. You know, you contract into a marriage, you know what you're in for, you know who you're marrying, generally speaking. And if you are marrying someone who you know is not going to contribute as much to the marriage as you are, and you choose to get married in community of property or with the accrual system, you know what the consequences potentially could be. So you can't just get out of it just because it doesn't suit you.
Yeah. I totally agree with you. And I think it just goes back to educating yourself once more. So, I mean, like seeing an attorney before actually entering into a marriage, making sure that you know what the different marital regimes actually entail, and making sure that you really want to get married in community of property. So, in saying that, are there any like misconceptions that you find the public has in regards to forfeiture?
I think everything that we've discussed is a misconception because everybody believes they come in here and they say, look, he was a lousy husband or she was a lousy wife. She's not sharing in anything that I've built up. And that misconception exists throughout society. They think it's the golden bullet. They think that just because someone wronged them, they are not going to have to share in their wealth. And unfortunately, it's a massive misconception.
Okay, so I mean, like, are there then any steps that individuals can take to protect themselves from potential forfeiture in their divorce?
Well, absolutely. If you conclude a robust antenuptial contract where you exclude things like, for instance, in this particular case that we're referring to, the woman could have excluded her business, or she could have excluded her starting values, or she could have excluded any assets that she'd gained or was about to gain before marrying the husband. And that's where it boils down to taking proper legal advice before you enter into a marriage. But unfortunately, and we see this a lot, is a lot of society doesn't accept or understand that when you conclude a customary marriage, so an African customary marriage where literally all you need to do is celebrate the marriage, pay lobola, you are married in terms of customary law. And that means marriage automatically in community of property. And that may have been the case in this scenario, that she didn't actually believe or understand that she was already married in the eyes of the law. So that is also a myth that needs to be debunked.
So you now mentioned getting proper legal advice. What would you say people should look at before, like when they are deciding which attorney to use to draft their antenuptial contract? Because ultimately it is a big decision.
So I wouldn't just look at cost. You can't go on the person that's advertising it for the lowest amount of money. And in fact, if a lawyer is advertising a cost, they are touting, and they should not be allowed to be doing so in the first place. You need to do your research thoroughly, find somebody who is a family law specialist and not, for instance, a contract lawyer or an environmental lawyer or someone that you know from school who can do you a favor. It's a big, big decision to enter into, and it's much the same with any type of contract. You get your legal advice up front rather than waiting for it to unravel at the end. So it's you pay up front rather than pay a lot more later. What do they say? Goedkoop is teerkoop.
Yeah. You pay peanuts, you get monkeys. That's also something that I hear a lot. Okay, cool. So then moving a bit on to the case that you sent me, which was the case of Greiling versus Minister of Home Affairs and others. So this actually had to do with marriages out of community of property without accrual. So before we discuss the case, I know you mentioned the free marital regimes, but do you maybe just want to tell the listeners a bit more about marriages out of community of property without the accrual?
Of course. So a marriage out of community of property without the accrual essentially does not have any financial implications upon the termination of the marriage, aside from perhaps maintenance of the spouse, if there was a maintenance relationship, and maintenance of children. But essentially what happens is that each spouse has their own basket of assets, and they come into the marriage with their basket of assets and they leave the marriage with their basket of assets. There's no sharing between the respective spouses. So if, for instance, I am a non-working wife and I stay at home and look after the children, and I came into the marriage with nothing, but my husband is a very high-powered executive and accrues assets, and we decide to get divorced, even if he, let's say, had an affair, the likelihood is that I'm going to leave with nothing aside from perhaps maintenance for my children and maybe maintenance for myself. That is the case with out of community of property without accrual marriages. Now, what the Greiling case has done is it has affected Section 731 of the Divorce Act, which is the section that deals with redistribution orders. And what redistribution orders pertain to is marriages pre-1984. Well, this was pre the Greiling case. It would only pertain to marriages before the coming into effect of the accrual system. So if you didn't automatically have access to the accrual system because you were married such a long time ago, then you could apply for a redistribution order upon dissolution of your marriage or upon divorce of your marriage, if you felt that you were not going to be, if you were being unduly prejudiced by the dissolution of the marriage. So for instance, if I was the wife in that scenario. And what happened in the Greiling case is very similar facts. The wife was a stay-at-home wife. She was married after 1984, so she was married, I think, in the 90s, and they got married without the accrual system, despite having concluded an antenuptial contract. And what the court has said in this case is that they can now order redistribution, even though they were married post-1984. So it affords a large amount of discretion to the court to interfere with your matrimonial property regime. So it's created a lot of debate in legal circles, because on one hand, people are saying, well, this is fair because maybe the wife was she was on an unequal footing, for instance, when she entered into the negotiations insofar as their matrimonial property regime was concerned, or she was uneducated in that regard, and the husband was high-powered, it would have been his lawyers. So it's only fair that the court can interfere and make an order of some form where they pay across a portion of his assets to her upon the dissolution of the marriage, even though they were married not in community of property and not with the accrual system. But the other half of the argument is, well, how does this affect contractual freedom? Because contractus pansivanda says that the contract must prevail, and we've entered into an agreement that you're not going to get anything out of my estate when we divorce, but now the court is reaching its arm into that contract and saying, actually, we disagree and we're going to pay you an amount of money. So it's set the cat amongst the pigeons in the very strongest sense of the word, because almost all of the divorces that we have, which are out of community of property without accrual, are now filing amendments and saying we need to go to court because now there needs to be a redistribution because I don't believe that it's fair and I contributed to him being able to build his estate up. And I'm just using him because it's often the man who unfortunately is the wealthier party. But, I stayed at home, I looked after the children, I let him build up this empire, and therefore on the grounds set out in Krailing versus Krailing, I should be afforded a portion of his estate. But it's yet to be seen how this is going to be applied in our courts. We've got a lot of matters now going before the court on the basis of Krailing, but personally, I don't agree with the decision in Krailing. I think that the decision in the law of contract should prevail. You have the option to get married with accrual and thus should have that. But I think the issue actually stands, and it's what you touched on in the beginning of the podcast. The issue actually is education. And do people know what they're getting themselves into when they get married out of community of property without the accrual system? And if that was stronger, if the education in that regard was stronger, then we wouldn't need decisions like Krailing versus Krailing, which really make for no legal certainty whatsoever. So it's a bit of a difficult one to deal with.
So that's quite interesting. And do you have any tips for, let's say, stay-at-home moms or stay-at-home dads, maybe, on how they can actually protect themselves, regardless of how they are married?
Well, firstly, get married with the accrual if you intend on staying at home. But secondly, ensure that you co-own assets. So if you're married out of community of property without the accrual system, try and make sure that when you buy assets or enter into any type of pension funds or retirement annuities, that some of these assets are actually registered in your name so that you're not left high and dry at the end of the marriage. Krailing aside, if Krailing could be used.
So, I mean, like, you deal with family law a lot. Do you foresee any changes or future changes happening in the near future?
I do think that Krailing in particular is going to be refined. I think there will be a lot of case law that comes out that sets out perhaps the factors that can be used in this regard, because it's definitely not clear from that case itself. So we're eagerly awaiting how the courts are actually going to deal with that decision.
Amazing. So, do you have anything else that you maybe want to tell our listeners about forfeiture or marriages out of community of property without the accrual?
No, I think I just want to tell your listeners to make sure to educate themselves. Marriage is not all happiness and roses. Unfortunately, when you enter into it, you're entering into a legal contract, and you need to make sure that you know exactly what you're getting yourselves into. And unfortunately, it's a difficult pill to swallow because obviously you've just gotten engaged. It's all happiness and sunshine, and now you have to contemplate the end or possible end of that relationship. And that is not something that people like to do.
So, Megan, thank you so much for joining me on the podcast. Thank you for educating our listeners. And where can they reach you?
They can reach me at info@hjwattorneys.co.za, or they can check out our website at www.hjwattorneys.co.za. We also have quite a big Instagram profile, also hjwattorneys_conveyances.
Thank you for listening to this episode of the Justice in Heels podcast. If you enjoyed this episode, feel free to share it with your friends on social media and tag us. As this podcast has a legal element, just a quick disclaimer that all views expressed in this podcast are not necessarily the views of the firms, companies, or brands that we are associated with. Until next time, goodbye.